There have been several developments in the last few days where legal arguments, political narratives, and public perception are all colliding around Israel. First, we've seen Israel remain in the 2026 Eurovision Song Contest, despite attempts by the tournament's broadcasters in Spain, Ireland, the Netherlands, and Slovenia to kick them out. After failing in that attempt, those broadcasters are currently boycotting the event. At the same time, the UN General Assembly has passed another round of sweeping resolutions calling for Israel's withdrawal from what it terms occupied territories while omitting any reference to terror organizations or the wider context. And finally, we've seen more than 200 cultural figures signing a letter calling for the release of Marwan Barghouti, a man convicted of multiple counts of murder and terrorism. To unpack the legal realities behind all three of these issues, I'm joined by the legal director of UKLFI Charitable Trust, Natasha Hausdorff. Natasha, thanks for being here.
Thanks, David. Always good to be with you.
Well, let's start with the big one. I remember a time when it was controversial that Bucks Fizz showed their legs, but a number of broadcasters are now refusing to participate because Israel is still in Eurovision. Can you give me your reaction to that and explain what the EBU rules actually say and whether member broadcasters are allowed to boycott another country in this way?
Well, thank you, David. It's clear from the EBU's decision that there was simply no basis upon which to exclude Israel from the competition. And it's important to remember that this is a union of broadcasters. So it's not the country itself that sends a representative. In theory, it is the broadcaster that participates in the union. And quite frankly, there was simply no basis upon which to exclude Israel from Eurovision on the rules that govern the competition. This is clearly a political attack on a participant, a politically targeted attempt at exclusion. And I think it is important that we recognise the European Broadcasting Union, the EBU, that runs Eurovision. It has its seat in Geneva. It is therefore regulated by Swiss law, and there is a governing statute which sets out the membership obligations. Membership carries with it the obligation in particular at 3.7.1 to further the purposes of the EBU, which are set out in Article 1.2. Those purposes include the purposes to contribute to the field of broadcasting, safeguarding and improving freedom of expression and information, which is one of the essential foundations, it says, of a democratic society and one of the fundamental conditions for its progress and the development of every individual, enhancing the freedom and pluralism of the media, the free flow of information, ideas, and the free flow of opinions, developing cultural diversity, intercultural dialogue and exchanges in order to promote tolerance and solidarity. All very fine objectives, but it's quite clear in these circumstances, in the circus that has ensued in these attempts to get Israel excluded, and now, as you've indicated, the decision by the Irish, Spanish, Dutch, and Slovenian members of the EBU to boycott this coming year's competition, that does appear very strongly to me to be a breach of these articles of the statute, in particular Articles 3.71 to 3.74. A failure, really, to further these purposes, to contribute actively to radio, television, and new media program exchanges. And fundamentally, and this is what the Eurovision stands for, to abide by that spirit of solidarity, good faith towards the Union, its activities, and other members. That's clearly a failure on the part of these four members of the EBU that are taking this disturbing action. And of course, this comes on the basis and on the back of the treatment of Israeli participants for a number of years, despite the fact that on the back of the virtue of the song submissions, these submissions have done tremendously well in the public vote. Israel actually won the public vote at the last competition. but came second overall due to the votes from the juries. I mean, in these circumstances, it would seem prudent for the board of the EU, the executive board, to take enforcement actions that are available to it against those boycotting states. They're set out in terms of the sanctions that follow from infringing acts or behaviour. Now, they can start, of course, with formal warnings, but frankly, the sanction of expulsion is available to the executive board of the EBU for those members that are behaving in such a disgraceful fashion, acting in such flagrant violation of the statute. So, David, ultimately what we're seeing is a further epitomization of the rules being turned on their head. This attempt to have Israel excluded on the basis of these bogus arguments, and ultimately the breaches of the rules, the statute of the EBU by these now boycotting states. And this attack, if you will, on the rules and on the law, the governing laws of the EBU in this respect, is something that we are seeing across the board. These epitomizations of different attacks on the law as far as Israel is concerned.
And this comes, Natasha, as the UN General Assembly overwhelmingly passed resolutions this week demanding Israeli withdrawal and asserting Palestinian inalienable rights. What legal status do these resolutions actually carry, and why are they often misrepresented as binding international law?
I think it's really important to stress that whatever comes out of the General Assembly is political and not legally binding. There is a very narrow mechanism within the United Nations for passing resolutions that are binding, and that is specifically under Chapter 7 of the UN Charter. These are Security Council resolutions that are explicitly passed under that chapter, and they are very few and far between. So the General Assembly deciding to adopt these texts, as you say, on pretty overwhelming majorities in the context of these votes, is simply a political statement. But the disturbing aspect of the content, not just of these texts, but also of the discussions that surrounded them, is the repeated mistaken references to international law, and perhaps even worse than that, the continued misrepresentation of international law through these political mechanisms. Now, one of the central facets of the impetus to pass these resolutions, certainly from the discussion and the UN press releases, appears to be this demand for self-determination for the Palestinian people. It is suggested that this is an inalienable right. There is a great deal of scholarship, of course, on what self-determination means in international law, but ultimately, practically, factually, the Palestinians have enjoyed self-determination ever since the Oslo Accords, the creation of the Palestinian Authority in areas A and B of the West Bank, and certainly ever since Israel's withdrawal in 2005, the Palestinians have had self-governance, self-determination in Gaza too. So the premise upon which these resolutions have been passed is a very disturbingly false one. But then we come to some of the serious omissions that these texts unfortunately suffer from. There is no reference to the disarmament of Hamas as being at the core of what is required for progressing to stage two, of course, of the proposed ceasefire plans in the Gaza Strip, and generally for progressing to what these texts call for, which is a peaceful resolution to the current situation. There's no reference to condemnation of Hamas, no reference to the 7th of October attacks, the massacre, or the need for dismantling the terror infrastructure in Gaza. And that omission, or these series of omissions, is very striking indeed. Coupled with that, you've got additional misrepresentations of the international legal framework, references to the international community being required to take firm action, that's a quotation, to compel Israel apparently to comply with International Court of Justice decisions. What they're referring to there are the likewise non-binding legal advisory opinions, as opposed to any decisions that require implementation or indeed compliance. And we have a slew of false allegations being levelled by representatives, for example, from Qatar. And what's striking in respect of a great deal of the text and the content is that it flies entirely in the face of the recent UN Security Council resolution 2803, which underpins the important next steps, including reform of the Palestinian Authority, before there can be any question of a route through to Palestinian self-determination or the concept of a Palestinian state. It makes it perfectly clear what the requirements along that route are. And as I say, this General Assembly action has contradicted that Security Council more. It's still not legally binding, but it's certainly more authoritative than the General Assembly. This recent text, unfortunately, completely flies in the face of that, as well as settled international law on a whole host of subjects.
And of course, this is the same week that we've also seen more than 200 cultural figures publicly calling for the release of Marwan Barghouti, despite his convictions for multiple murders. What is the legal reality of Barghouti's case, and why is it problematic to frame his release as a peace measure?
Yeah, so this is pretty extraordinary and deeply disturbing when one looks at some of the names. Stephen Fry included, Miriam Margolyes, those individuals also who present themselves as Jewish or having some affiliation to Judaism that are calling for the release of this convicted murderer, as you say, and terrorist. Something that was interestingly left out of the context of the letter that they lent their names to. So Marwan Barghouti was one of the leaders of the Second Intifada. This is the Palestinian campaign of terror, suicide bombings, shooting attacks on Israelis between 2000 and 2005. He's not an innocent Palestinian leader or simply a parliamentarian. He was convicted in the Israeli District Court on 5 separate counts of the murder of civilians. Crimes that were orchestrated by Barghouti included the murder of a Greek monk in Jerusalem on the 12th of June 2001, the murder of Yoel Chen in Jerusalem on the 15th of January 2002, the murder of Eli Dahan, Yosef Habi, and Salim Barakat in Tel Aviv on the 5th of March 2002. Now, he was also acquitted of 21 counts of murder in 33 other attacks due to a lack of sufficient evidence. And he is, importantly, the founder and senior official of the designated terrorist group, the Al-Aqsa Martyrs Brigade, which was responsible for massacring dozens of Israelis in suicide bombing and shooting attacks within that period of 2001 to 2005. This is all, of course, information that was entirely omitted from that letter. During the 2 trials that Barghouti was involved in, it's important to stress, showed no remorse for the murders that he committed. What's particularly disturbing about the omission of these convictions, or indeed the suggestion that these proceedings were in some way illegitimate, which is what the signatories to this letter have suggested, is that it is again an attack on the law. It is upending the recognised legal framework under which these convictions were obtained. This is an Israeli court that had jurisdiction in accordance with the Oslo II Accord. Now, Oslo II is an international agreement that has international backing across the board, including the United Kingdom. It's one of the endorsers of this framework that was established. So to simply set aside the lawful outcomes of legal processes, and in this case, criminal trials, simply because they are not convenient to the political calls that are being sounded for the release of this convicted murderer and terrorist, is very concerning indeed. And in particular, it's concerning that while the original campaign website, the sort of Free Marwan website, does contain references to his conviction and imprisonment, these aren't included in the statement that these signatories have been asked to sign. So again, upending rule of law, doing away with the framework and the provisions of the law in this respect, and the fact that actors and other public facing officials have been duped into signing this is of great concern.